Toothpaste stuffy. That's one.
Any mention?
May it please your lordship. My lord, this is the same contract matter, the Assam Rifles matter, my lord. In the last occasion, it was disposed of with a direction to dispose of my representation by Monday, my lord. Today is Tuesday. They have, of course, disposed of the issue that I have raised, my lord, has not been addressed. So I'm praying, my lord, this matter be listed. I'm filing it today. They will be listed on Friday, my lord, for motion. Friday, my lord.
Okay, yeah, Friday I'm here. Yes.
My lord, oblige.
May it please your lordship. My lord, I beg to mention item number 12, my lord, hearing. I appear on behalf of the corporation, my lord.
For the petitioner, your lordship.
He has objections?
No, your lordship.
No. What is the problem?
My lord, this matter is led by Mr. Amit Kumar, my lord. He's on bereavement.
Okay.
My lord, may I kindly have this matter on the 8th, my lord, 8th of August, if convenient to your lordship. Tuesday, my lord.
Why it? Some urgency is there from your
No,
part?
my lord, the only thing is that on the 8th, AG doesn't have any matter in other courts, so he'll be, he will save the time of this court, my lord.
No problem. Okay, 8, right?
Highly obliged, lordship.
Yes.
Your lordship, I beg to mention items number 22 and 25.
22 and?
25, your lordship. Mr. Shulai is on leave.
Miss, which one should I? ND July?
And Shulai, your lordship.
22 and 25. Yes, this also as the Argy Council state will be in sanction leave.
Obliged.
No objection. Very good. Yes.
Lordship, I beg to make a mention for item 7 from supplementary list, Lordship.
7 supplementary list.
Yes, Lordship.
7
All is
hearing.
out of station, Your Lordship. Yes, Lord.
Amilur Rahman.
Yes, Your Lordship.
No objection, your lordship.
Yes. So the all NOCs, no objection councils, right? Yes. 2 weeks. Yes.
Similar prayer for item 13, Your Lordship.
Of
Okay, the lady list.
the main list.
Yes, Lord.
13, Salim Khan.
Yes, Lord.
You're for the respondent.
I'm from respondent.
Where's the petitioner? Yes, Ms. Harika, you have some objection?
7 and 9, Your Lordship. I'm from respondent and 9.
And for the petitioner, your lordship.
1 week. 2020 matter, yes.
Yeah, please, sir. I beg to mention item number 10, your lordship.
10,
10, yes, lordship.
Malati Prasad.
Your lordship.
Where's Mr. Sheikh?
He's out of station, your lordship.
Where's respondent? You have no objection?
No objection.
19 matter, 1 week is. What's the matter about? Is it a matrimonial dispute or what is it?
Your order, we have come to the court to close the written submission. No?
What's the matter about?
Actually, this it's need to be the record should need to be
The matter has heard, your lordship. The court has called for the record.
Item 10, main list. I want to call. Yes, take down in this matter. Item number 10 in this records as requisitioned by order date 5/7/2023 have since been received by registry staff. However, praise made on behalf of the petitioner for adjournment due to the absence of Mr. S.A. Sheikh Army Council upon this matter after 2 weeks for hearing. Yes. 2 weeks.
May please, Your Lordship. Lordship, I beg to make a mention item 14, Your Lordship.
Item
14.
1-4.
Yes, Your Lordship.
For the petitioner, Lordship.
Are you still appearing? Who's appearing here? The counsels haven't changed.
No. I'm there.
It's a sad story, Mr. Chairman.
Mr. Chaudhary was there when he appeared when I was out of station.
Who was there before? You? Or you were there only from the beginning?
You're Mr. Paul. Mr. Paul.
You, Mr. Paul? Oh, yes, okay. 1 week, we'll dispose it of on merits.
Yeah,
Yes.
because the week after, I will be out of station. It will be, if next week it can be taken up.
Let's see. Matters are.
Obliged.
I'm getting a negative signal from the court master. So it'll have to be after 3 weeks. Yes. Yes.
May it please your Lordship. Lordship, I beg to make a mention of item 18. Lordship, I'm praying if this matter may be listed next week.
What remains in this case?
Lordship, the matter is to be heard on merits.
On when? After 1 week?
Lordship,
2 weeks, yes, okay.
much obliged, Lordship.
Supplementary list, item number 1.
May I please, Your Lordship? This is a contempt matter, my Lord, where my Lord has passed an order that my representation which I have filed before the respondent was required to be disposed of, my Lord. If my Lord may kindly come to page 34. Para 7, my Lord. Looking into the fact personally and the issue as raised, notwithstanding the issue of locus, the respondent are directed to address the representation dated so and so, which appears at annexure so and so of the writ petition, so as to clear the year with regard to the issue. The same shall be completed within a period of 2 months, my Lord.
15-5. Now we on. Okay, correct, Mr. So-and-so. Issue notice returnable in 2 weeks.
And
Steps to be taken by Reset AD
we'll take the steps.
within 3 days. This thereafter list also.
Item number 2.
May it please your Lordship.
Yes.
May it please your Lordship. Also, the petitioner hearing was serving as reader.
As a? Serving as? The postal exists, reader.
Nowadays, my lord, do not exist. Professor, assistant
associate.
professor, then assistant professor.
Yes. Yes.
In the last appointment, she was designated as a reader, my lord. My lord, what happened during the COVID time, even though she was working online, she was asked to give leave application. And thereafter, she filed an appeal. And the appeal is at page. My lord, at page 100, my lord. Annexure 22, my lord.
Page 100.
Yes, my lord. Annexure 22.
Yes.
My lord, this is an appeal for confirmation of the leave for the period of 28th May to 14th June 2020 and from 11th July to 12th December 2020. She submitted an appeal whereby she has stated all the details of work that was assigned to her. That is at page 102, my lord. This is all the contents, and she has annexed everything, wherein she has been reporting online and doing her academic activities. However, despite of the fact that she has been doing online activities, she was asked to submit an application for her leave. And thereby, my lord, we are here before your lord. Her appeal was rejected. My lord, the rejection order is at page 253, my lord.
$253.
248, my lord, 248. 248. I apologize, my lord. 248. Annexes 23, my lord.
Okay. Yes,
An
Mr.
appeal
Sen.
for condemnation
Yes.
is rejected. And my lord, there is one more prayer, my lord, her pay fixation has been wrongly calculated. My lord, as per the government notification, that is
You're
that,
putting two cause of actions in one writ petition.
my lord, it's a similar cause of action because the representation also considered the same. So thereby, my lord, we are
Yeah, we'll issue
punishing
notice,
it.
Mr. Sen. You'll accept notice.
Yes.
Yes, sir. Heard. Mr. Name? SP Sharma. What's your name? Pathak?
SP Sharma.
SP Sharma. Service inshallah counsel with the petitioner. With you are?
Mr. Yampala.
M. Talang.
A.M. Pala.
Oh, yeah, Pala, sorry. With M. Pala, sir. Issue notice, Mr. S.N. Standing Counsel Nehu is present except on behalf of respondents. Just list after 3 weeks on affidavit published. Yes.
Much obliged, my lord.
Item number 3.
Mr. Kanta still in hospital?
Your Lordship, he's out of the hospital, but he's still not well yet, Your Lordship, to come and attend court.
Yes, Mr. Nopla?
May it please Your Lordship. Lordship, there has been a long pending dispute regarding the boundaries between the two villages, Nawhali and Minriang village, Lordship. And then way back in the year 1992, Lordship, it has been, the boundaries between these two villages has been somehow settled by the CM of Himachal, Prof. Respondent, Lordship. But
92?
Then, in 92. But then again, Lordship, the respondent number 5, that is the headman of Minriang, has kept on asking more land from the Prof. Respondent, Lordship, from the CM of Himachal. And as per the order, Kahukum dated 1st March 2001, the Prof. Respondent has rejected the plea of the respondent 5, Lordship.
Okay.
And it is interesting to note also, Lordship, that due to this dispute, there has been an incident in which the residents of Minriang, they have burnt the charcoal of the residents of Nawhali village. And the CM of Himachal has ordered them to compensate for the damage of the charcoal, and pay rupees 1,58,000. But up till date, nothing was
So
paid.
what I agreed with now, Mr. Nopla?
Now, Lordship, in short, Lordship.
Now you say that the boundary dispute was settled in 92.
And then, Lordship.
And the order was passed in 2001.
2001.
Now what happened thereafter?
Thereafter, Lordship, there was dispute after.
So you were happy with that earlier
yes, Lordship.
demarcation?
And then the respondent of 5, that is the headman of Minriang, they kept on asking land, and in which ultimately the Prof. Respondent has passed the order dated 9 December 2015. Annexure 3, page 51, Lordship, in which it is here. It's a bit long order. Here, Lordship, the Prof. Respondent has passed the order after the Ministry and Bakrao has made a local inspection and have taken the confidence of both the villages. That means the respondent of 5 as well as the petitioner, Lordship. But again, after that, Lordship, the respondent has kept on.
And then again, this one, that demarcation was done.
Demarcation was
that
done.
Was done in 2015 again. So you're happy with that? This new demarcation also?
We are happy with the demarcation of as per the order of dated 9 December 2015. We are happy with that.
Then what happened after that?
But after the respondent kept on asking more land, and ultimately, Lordship, I'll come to Lordship, and then after that, they have filed one petition before the KHDC, and the KHDC.
Who filed Menyang Village?
Menyang Village, and the KHDC has directed the same of Hima Harim, that is professional respondent number 6, to give a fresh boundary. In which.
But you mean reopening the whole boundary dispute again? You say
Yes.
that it was 92 was demarcated once.
92 once, and then 2015
again. Then again they raked up the same issue.
The same issue, Lordship. And then they have written a letter to the KHDC, and the KHDC in turn has directed the professional respondent to again give a fresh boundary. So we are being aggrieved by that, and then we have approached this Honorable High Court also by way of writ petition. Number 166 of 2022, in which this Honorable High Court has directed the KHDC to expedite the proceeding and to settle the matter once and for
all. So what happened before the executive committee?
And then again, Lordship, the executive committee has passed the impinge order dated 1st June 2023, upholding the impinge order which was passed earlier. That means the fresh boundary which was passed as per the wish and the.
Where is the other order then, which was upholding? Then after 15, there was not an order.
After 15, there was no more order, Lordship. And
in fact, upholding the impugn.
In fact, Lordship, since 2015, both the villages have been living peacefully, and they have been cultivating their crops in their own lands, in their own. But then suddenly, in the year 2021, they have filed a petition to the KHDC, in which in turn the KHDC.
Where's the petition they filed? Let's see.
Lordship.
How can you keep on redeciding one matter which is. There's a complaint, page 80. No.
Lordship, can you come to annexure 6, Lordship, page 68.
What is the petition for this council? No, where's the petition that they file? Is a complaint against what?
That petition is not there, Lordship.
Why?
The petition is not there, but then.
You were not made party.
Whom, Lordship?
Before the council?
We were made a party.
Then you don't have a copy of that complaint they made. He said that upholding the impugn order, if there was a fixation, refixation, and refixation again, then they file a complaint.
Yes, Lordship. That complaint is not there, Lordship.
I think you better supplement your petition, then you bring all the materials. Any issue notice, you'll accept notice on behalf of the respondents.
And then, Lordship, there's a petition to stay the impinge order also, Lordship.
Mr. Nokla also did not. We've been very clear with the materials.
Lordship, my humble submission is that.
Notice first. Then we'll take interim.
Lordship, my humble submission is that since the year 2015, when that order was passed, there was peace and harmony between the residents. But now, due to this impinge order, the residents of Menyang village has tried to encroach into the land, into the portion of the Nohali village, and in fact, they have come and told them to vacate even their fields and their crops and all that.
Let's see the impinge order.
So, impinge order is in.
You place it, yes.
Impinge order.
Page 88, yes.
88, Lordship. Should I read? The village Nohali and Menyang were combined as one until the year 2000, when they were separated with different administrations. When Menyang village were separated from Nohali, the boundary of the two villages were demarcated with regard only the forest of the villages, but with regard to the community land, Ribamlang, the CM has instructed them to jointly manage the same for the time being. Therefore, the boundary of Ribamlang has not been able to demarcate until date, in spite of the facts that attempts were made by the HIMA that misunderstanding has arose between the two villages, which has been to resolve amicably by the two village darbars. The office of the same HIMA village has passed the order dated 9/12/2015 in connection with the boundaries of the two villages, including the community land, Ribamlang. The village Menriang was not satisfied with the order Hukum dated 9/12/2015. Therefore, has filed an objection to the Executive Committee, Khasi Hills Autonomous District Council. The Executive Committee vide order dated 15/4/2016 has ruled that the order dated 9/12/2015 cannot be operative as the Executive Committee has not approved as per the KHTC Administration Elaka Act 1991. Therefore, the order of the CM HIMA Herim dated 9/12/2015 is hereby vacated. That after the office of the CM HIMA Herim has properly considered the matter, it has again demarcated the boundaries of the two villages. Vide order dated 3/6/2016, in which the Executive Committee vide order dated 14/6/2016 has approved the order of the CM HIMA Herim as per Section 3 of the KHTC Administrative of Elaka Act 1991, that the village Darbar Nahali was not satisfied with this, and as such has filed a complaint to the Executive Committee. The Executive Committee vide order dated 24/10/2016 has passed the order vacating the order dated 3/6/2016 and its own order dated 14/6/2016. That as per this order, the Executive Committee once again upheld the order.
It's all right, Mr. Nongklau, we understood. I've seen the in-between order. The thing is that the 15 order which you're happy with, that was not approved by the District Council. So again, there was a review of the order, and then another order came out, which demarcated, and then in 24th October 2016, 15 orders upheld again. That was again, they filed a fresh appeal against the order. That was set aside again, and finally they said that the last order, they heard the matter and have gone back to the order dated okay, issue notices.
Lordship, kindly state the operation of this.
Mr. Nongklau, without hearing the other side now will be difficult, because we'll issue the order for hearing interim application. You take steps immediately. Heard Mr. H. Nongklau, the council petitioner, issue notice. Stop. Mr. Mentions made on behalf of Mr. B.K. Kanta, who stated to be indisposed by MSc Nongklau, who, however, had been instructed to accept notice on behalf of the respondents number 124. Stop. Petitioner to take steps for issue notice on respondent number 5 and 6 by CPD within 3 days. Stop. A prayer has been made for an interim order on the plea that, as the matter involves a dispute between two villages, and due to the impugn order was passed on
1st June this year,
and due to the impugn order 1st June 2023, there's a likelihood of the respondent number 5 exerting undue pressure on the petitioner village with regard to use and occupation of the lands therein. Peruse in the impugn order, it appears that for effective adjudication, the presence of the private respondent is absolutely necessary if any further orders are passed. Stop. Issue notice also on the interim prayer. The same to be taken up on the next date. In the meanwhile, status quo shall be maintained by both the villages till the next date.
Item number 4.
Yeah, please, Your Lordship. It's regarding the Village Employment Council matters, Lordship.
Yes.
Lordship, the petitioner is a job card holder of the Tungurara village, Lordship, which falls under Zigzag CNRD block, Southwest Garo Hills, Lordship. Here, what has happened, Lordship, in this village, the Village Employment Council under Mahatma Gandhi National Rural Employment Guarantee Scheme was constituted in the year of August 2017. And the term of the VAC was expired on August 2020, and thereafter no election was held, Lordship. It was supposed to hold the election after the expiry of the term of 3 years, Lordship. But till date, no election was held or conducted by the respondent number 4, Lordship. Whereas, as per the notification, Lordship, dated 23/03/2010, Annexure 1, Lordship, page number 11. Kindly come to page number 11, Lordship. Where it is stated, Lordship, in para number 4, Lordship. Annexure 1, page number 11. I'll read out, Lordship.
Yes.
Against para 7b, clause 7, the term of AEC and VEC members will be of 3 years,
okay,
Lordship. And it is also stated, Lordship, in the notification, Lordship, 18 January 2022, Annexure 2, page number 15, Lordship.
Secretary VEC shall be 100% shall be kept for women members. Okay, yes, who's appearing for the state? No elections have been held here?
Your Lordship.
Yes?
I'll take instructions on that, Your Lordship.
When was the matter filed?
The matter was filed on Tuesday.
Your name?
My name is Alan Arang, Lordship.
Heard Mr. Arang is counsel the petitioner. Issue notice. Mr. Ian Pala. Your government advocate.
Yes, Lordship.
Is present accept notice on behalf of all the respondents for the notice called for. This is matter after 2 weeks for instructions or activities.
Highly obliged, Lordship.
Item number 5.
Also for such an activity.
Item number 5.
I just point out, my lords, lordships had appeared for the petitioner in an earlier round of litigation.
Yes. This is matter for any other bench or me.
Obliged, lords.
Six.
The instructions, my lord, is I'm withdrawing it with the liberty, my lord.
Yes, Mr. Thapa submits that on instructions, be allowed to withdraw instrument applications with liberty to approach appropriate forum. Yes. He has allowed, matter stands closed on withdrawal with liberty as spread. And there's no point.
I understand, my lord.
I understand the difficulties of people, but we can't create a precedent.
Right.
Main list item number 1.
But affidavit will be filed course of the day.
We have to receive some documents from the respondent. I pray for further 3 weeks time.
3 weeks time?
Yes, Your Honor. We have to receive some documents and the respondent is from Garo Hills, so
Doesn't matter, Garo Hills is where, another planet.
I humbly pray for 3 weeks time, Your Honor.
No, no. MSR Goni for response 1 to 5 submits that this after we find across the day of on behalf of respondent number 7. They is made for 3 weeks time. The same decline affidavit should be filed within 1 week. This is the matter on this one.
2 weeks.
Okay, 2 weeks.
Item number 2.
Here, my lord, the
Objections
objections
filed?
were not filed, my lord. We're seeking
Why?
some more time. They filed a very detailed manner, very bulky 711.
Lordship, 711 application.
Take some time, my lord. Just
You
bring
file
for 5 days
application
time.
for
Yes,
extension
my
of
lord,
time.
it is ready.
Yes, today the matter is fixed today for hearing on objections to the application under order 7 or 11 stuff. I was in an application filed by the election petitioner praying for further time for filing an objection due to unavoidable reasons. Stop. Accordingly, the application is allowed. But how much further time?
Well, next week, any date, my lord.
2 weeks further time granted. This is a matter of concern.
All right.
Item number 3.
No, please, Your Lordship. Your Lordship, I need sometimes to file my reply. Your Lordship.
What reply?
We just received the petition recently, Your Lordship.
CRP, there's no question of reply. Legible copies you have supplied?
Yes. Just recently, Your Lordship. We need to go through also, Your Lordship.
Yes, what's it for today? What's the matter about? Is it a maintenance matter? What's the matter about? You have the brief with you? Who's your senior? Who? I think it'll be very difficult for you to conduct cases if you don't have the brief also. You don't know what the matter, what's the matter about also. Very unfortunate. Parties are present but sick, but the counsel for respondent seeks time to examine the petition just after 3 weeks.
Highly obliged.
Item number 4.
Your Lordship, the state has already filed a affidavit, Your Lordship.
What about number 4?
You haven't filed it.
You 1 to 3. Where's Mr. Kipi Bhattacharjee? For number 4. He's standing in the door, I can see him. What kind of way to conduct a matter? Not file rejoinder?
Your Lordship will be
Waiting for number 4's affidavit. Mr. Kiba find it very difficult to file affidavits, I've seen. He's not coming.
See him, sir.
Yes. Where will you file the affidavit, Mr. Bhattacharjee? Enough time been given. This is since this, it's
This fellow, I have entered appearance only.
doesn't matter. If 14/6 entered appearance,
Yes, ma'am.
then affidavit behalf of respondents on the past year respondents has already been filed. Stop Mr. Keyboard Chaji for respondent of 4 praise for allowed for the time to file affidavit. This thereafter.
State respondents give me a copy of that.
That is between you. I mean, we can't. You want orders for that also. Then you have to pay costs for not filing affidavit.
5.
May it please the Lordship. Your Lordship, I may kindly be given another 3 weeks' time to file my because we've got a parawise coming, but it's very sketchy. So we have sought for some clarification, Your Lordship.
If I can take your lordship, I'll just, of course, my friend has said submitted, all right. If I can take your lordship to the Annexion 9, that is at page 16,
Texture 9.
60.
60. 60 is the actual the page the relevant page, my lord.
Okay.
The para 6, my lord. On the last date, that is on 31/3/21, this court, on being apprised about this position, had directed the learned State Counsel for the respondent number 124 to obtain precise instructions as to whether the petitioner is being considered by the respondents for promotion to the vacant post of chemist, as has been indicated in the letter. Today, Mr. So-and-so, to learned government advocate, has referred to that part of the instructions received from the respondent number 124, wherein eligibility criteria for promotion and names of persons who are to be considered have been given. This note is taken cognizance by this court at this stage, and the eligibility criteria and names of the persons as submitted is reproduced. Now, para 7, my lord, a bare perusal of the eligibility criteria as set out is that promotion from among the assistant chemists will include persons who possess BSc chemistry and who have rendered not less than 5 years of continuous service in the post of assistant chemist. On examination of the table showing the names to be considered, it appears that from amongst the 3 persons who are serving as assistant chemist, presently the petitioner who appears at serial number 3 is the only one qualified for consideration of promotion, as he has the requisite prescribed qualifications as also years of qualifying service. Now, my lord, this was the observation, and with the above, my lord, in consideration thereof, and not to further prolong this matter, and keeping in view of the instructions and materials received and produced by the learned GA, without further examining other issues, this writ petition is disposed of as follows: that with regard to promotion to the post of chemist, as the petitioner is qualified in all respects for consideration thereof. Now, this observation, my lord, and this finding was on the basis of whatever was brought before your lordship. Whatever was brought before. Now, my lord, after that, my lord, when considering for promotion, the DPC, which was constituted, the DPC, my lord, found him to be not eligible. Now, my lord, a list of the candidates for consideration of promotion has been sent. Now the DPC is to consider who's to be promoted, who's not to be promoted.
Right.
Now, how does the DPC go behind the thing? That is our whole case. I mean, that is the
Let them file affidavit. It is yes, interesting.
That some clarifications required along these lines only, Your Lordship.
So in the meantime,
because it was found that
his name for promotion. Why was he found unfit?
He was found because he was not regular.
If he already came in a zone of consideration for promotion, as per the list provided by the
government, Your Lordship, at that point of time.
So if it comes zone of consideration and it is incumbent.
So when the DPC was screening all this, Your Lordship, it was found that the petitioner here, Lordship, was not had been appointed only on officiating basis initially.
Then you file affidavit.
No, Your Lordship, that is why we want to file a proper affidavit.
That is the only point.
Explaining all this, Your Lordship, because unless this is clarified, there
then that
could
was
be
never put forward by in the last round of litigation. So you.
And that is the only point
of time that he can be considered because his appointment is those qualifying years can't be taken into consideration.
That stand, my lord, that stand taken by the DPC. That is the only point to be considered, my lord, whether it is a bona fide stand or not.
AG with so and so. Pray for until further 2 weeks time to file affidavit. This is thereafter and so and so.
Effort shall be made.
Item number 6.
My lord, if your lordship observes, then
becomes effortless.
Effort shall be made to dispose of the matter.
This was filed only in May, actually, my friend. To oblige your lordship.
Well, the litigation is going on for quite some time. Anyway, oblige.
I pray for more time. 2 weeks time to file my reply.
Which client? This is a private case?
No, my lord. I'm for the state. This is a matter of compassionate appointment. Lordship, the paravised reply that I had received was very sketchy, so I'd asked for clarification, and the clarifications reached me this morning.
Nevertheless, the GA pays for 2 weeks time to file affidavit. This also.
7.
Please, Your Lordship. Your Lordship, as per the last order, we are to file the affidavit. My Lord, I pray for some more time.
2 weeks time already gone. Mr. Jian Tunja allergy, please sponsor for the 2 weeks time for affidavit. This thereafter also.
Much obliged.
8.
Please won't allow 2 weeks time for a tentative affidavit.
My lord, this is a very new case. It's coming for the second time, first time after motion.
Who's appearing here? Is that in our country or you?
My lord, I am appearing here with Mr. Andy Shirai, Additional Advocate General, my lord.
How much time?
My lord, 2 weeks, 3 weeks time, my lord. It's a still new
MS
case.
only in behalf of state response for the 3 weeks time for affidavit. Yes, thereafter also. Yes.
9.
Your Lordship, in this case, I may be given 3 weeks' time to file my counter, Your Lordship.
Mr. H. Abraham, the GA response allowed 3 weeks for a time for affidavit. Yes, also.
Hearing. Supplementary list item number 8.
I think we have not good luck for you, Mr. So, and in view of what should we write? This is matter after.
Yes, after 2 weeks.
Let them got another senior to appear. Yes.
My lord, in this matter, there are altogether 4 matters. 9 and 10, I am handling this matter.
No, but then the other matters, because people are charging now notifications come out. So it is.
In that case, if this matter can come up on 2nd, because there is some similar matter, I think, on 2nd.
No, let it come up to 2 weeks. To enable the government to.
Yes.
On the prayer of the learned. I write your name. Mr. R. Guru on behalf of the state and Mr. H. This is matter after 2 weeks.
Deputy Office.
Main list item 11.
Yes, Mr. Senior, ready?
Yes, yes.
My lord, in this matter, there are other respondents also, the school managing committee and the private respondent who has been appointed. I represent the state respondents, my lord. So basically, my lord, here they will be vital party because they have to respond.
They've been served, correct?
Yes.
So they have to reply.
Who are
to
the
that.
lawyers appearing for the private respondent?
N. Gurun, Your Lordship.
Who?
Gurun.
Miss N. Gurung for the private respondent, my lord, and Mr.
Who's N. Gurung?
Neelam Gurung, my lord, and Mr. Thapa for the school managing committee.
Mr. Thapa was here.
My role will be limited, my lord. As a respondent, my lord, my role will be limited. Managing committee will be required in this matter.
Yes, Mr. Nyoda, what to do? You didn't tell your friends to be present for the matter?
No idea.
No idea. Where's the from Mr. Paul's chamber? Who are there? Someone should be there. Who's appearing for respondent number 6?
Respondent number 6 is, my lord, respondent number 6, if I'm not mistaken, it's represented by N. Guru. She is the candidate who has been appointed.
Who's N. Guru?
Neelam Guru, my lord.
Never seen that counsel in this
She
court.
comes and sometimes, most of them she has missed this matter also.
Then we hear it ex parte, then no one appears. What about 4 and 5, Mr. Paul Juniors? No
My
one's
lord,
there.
4 is represented by Mr. Thapa. 5, I don't exactly remember who is representing.
Mr. Thapa is here. You ready with the matter?
4. Yeah, I stated.
Yes, 4 and 5.
No, 4.
Oh, Rajabala.
Haripur is not representing.
No, man.
Only 4.
5 I am not appearing.
It's a different school, madam.
5, all along There's been no representation.
Okay. And for the candidate also beneficial, the number 6 parent respondent also, no one's appearing.
She's not here today.
Can we conclude the hearing without the presence of the
My lord,
respondent?
if it'll be, my lord, 6 will be affected, my lord.
It's her appointment that
Yes, that has been challenged.
It doesn't appear next date, we will hear the matter. Yes, sir. When the matter has been called up, none is present behalf of point number 6. So, next line. It is submitted by MS Alconi that number 6 is a vital party. As much as any orders passed will affect her, will affect her services. Review the matter. This is a matter for 2 weeks. In the event no representations made in house number 6 is seen be heard in her absence. Yes.
All right.
Item 15.
Please, Your Lordship, we're supposed to file our bullet points, my lord. I'm just filing it.
What's the matter about?
We're challenging the seniority, my lord, the credition list.
Hearing has been concluded, Your Lordship.
Hearing has been completed, my lord. We're just supposed to file a bullet point.
Yes. Approval has been filed. Yes. Hearing concluded. Judgment reserved.
Lordship.
Obliged, Your Lordship.
16.
Along with Linda.
My lord, here, my lord, the caller, my lord, my lord, it seems two lands have been taken, my lord.
What's the matter about?
By the state respondent.
For land. See, your last date could not obtain instructions as
Yes,
by the score by order 14.6.
Yes, my lord.
The 14.6, what does it say?
The DMH had called up, my lord. Only thing is that he has requested for a week's time, my lord. Because it seems two lands are there, my lord. So there is that is why.
Oh yes, I remember now.
My lord, that is why.
There's an anomaly in the gift deed.
Confusion is with regard to the
gift deed of gift.
With the one of the annexures, my lord.
Yes.
Where the
So where are the records? There are 2 gift deeds there.
My lord, there are two gift deeds, my lord. So that is why, my lord, he is requested for a week's time, my lord. Because Karawal, it seems some problem is going on.
What problem is going on?
Some issues are there, my lord.
What issues are there? Only is already over the issue.
So he is
so
requested.
He's affected. Why he was a stone pelter or something? Then
he is requested for a week's time.
The can't take the excuse. Some problem is there. Who's that person? Give his name.
DMHO. I'll give his name.
Mr. Keyboard Patsaji submits that instructions are still to receive, but he prays that he be given for the 1 week's time to verify the same from the concerned respondent. This matter for 1 week.
Okay.
17.
May I please, Your Lordship? Your Lordship, I would like to withdraw this matter. Your Lordship will liberty to approach appropriate forum, Your Lordship.
What's the matter about MS Raji?
Implementation of the scheme, Your Lordship.
It's a normal matter?
No, implementation.
Okay. This MS and Raji prays that she may be allowed to withdraw this matter with liberty to approach the appropriate forum. So advises. So matter stands close to withdrawal with liberty as with liberty as prayed.
19.
Yes.
This matter relates to the installation of the water pipeline for 2 villages under the Jal Jivan mission. Under the scheme, my lord, the village communities are also allowed to implement And if the village authority unable to implement the project, then the department can implement also. And if the department implement, they used to issue tender process and select the competent contractor and implement the scheme. Now, in this instant case, my lord, the writ petitioners was selected by the 4 villages to implement the project, and his name was projected before the respondent authority, so that the respondent will grant the project, and the 4 villages by themselves will implement the project. Now, after recommendation made by the villages, this petitioner approached authorities to grant the project so that he can implement it. Now, in that process, my lord, the department unable to grant the project. Though other area they used to grant it, and there's some allegation, counter allegation is there that the petitioner say that the engineer asked 10% from the project for the MLAs and the department. So there was counter allegation. They deny it, no doubt. Legal notice were there, and they say that we cannot grant the project in this way. We have to go for formal tender process. So matter ends up there. On 9 March 2022, they issue a tender by the executive engineer calling for tender process to be open on 22nd March. So writ petitioner came to know this tender exercise on 16 March, and these are intervening 2-3-4 days of holidays. Therefore, he submitted the tender paper on 22nd March 2022 itself, on the day of opening. And the tender says that in the afternoon, tender paper will be open. So he went to the department, submitted the papers, everything, and awaiting the opening process. But the department officers say that wait for some time, officers are yet to be ready. So he was waiting in the office all day, unable to, he was never called, so therefore he left. And they said that the officer is unable to open it, so we'll see next day. So he left. On 17th, my lord, he received a verbal communication from some of the officers from the PHE department. The tender was opened yesterday itself at 22nd. And your recommendation by the villages were rejected, and therefore unlikely you will get the project, the tender process. Therefore, my lord, the petitioner filed the petition, and lordship, both parties has filed the affidavit. And 3 tenderers were there, including me and another 2 more tenderers. 2 tenderers are implemented as respondent number 7 and 8 and 9. I'm sorry, 8 and 9. Lordship has issued notice. They did not appear duty. They made the proceeded ex parte. Now, may I just take the charge of admission, the paper. Lordship, we kindly turn to page number 24, Annexure 2. This is the content of the policy, and I may go to the relevant portion, page number 60. Page number 60. 60, madam. 60. 1, 2, 3. 5 lines from the top, my lord. Your lordship see, in villages where Gram Panchayat, page number 60.
Yes.
In villages where Gram Panchayat and or its a subcommittee, VWC, this is a Village Water Sanitation Committee, my lord. Such, etc. is unable to execute the work. The PHE or such department will carry out the task after design estimate, etc. are presented to Gram Panchayat and its approval. However, management, operation, and the this maintenance will be the responsibility of the Gram Panchayat or its subcommittee and such. In my case, my lord, this village is unable to implement, so department took over. Now the policy says, my lord, page number 63 and 64, my lord. Page number 63 and 64. At the bottom, my lord, if I may read, for in villages, pipe water supply infrastructure and a related source development to be implemented by Gram Panchayat or its subcommittees and such, communities will contribute 5% of the capital cost in cash or in kind or in labor in hilly and forest areas, northeast and Himalaya states, and villages having more than 50% of ACs and or STs population and 10% of the capital cost. We are concerned with the 5%, my lord. In the northeastern states, the villages will contribute 5% cost, capital cost for the project.
Yes.
Now, thereafter, my lord, may I take straight away to the earlier recommendation, page number 139, 139. my name was recommended by the 4 villages to take up the case, my lord, to take up the project, implement the project. I just read my lord, the type copy, page number 139. 139, may I read, my lord? Subject selection of the contractor for implementing the Jal Jeevan Mission scheme, it says, my lord. With reference to the subject cited above, with the PWC of the 4 villages, Sansat, Mogenjing and Mogenjing, we have conducted a meeting on Sansat 2021 at Sansat in the community hall of the Sansat village. In this meeting, we have discussed thoroughly with regards to the selection of the contractor for implementing the Jal Jeevan Mission in all the 4 villages. With one voice, we have selected Mr. Jun Lingdo to implement the scheme of Jal Jeevan Mission in the 4 villages. The village water and sanitation committee of the 4 villages have made this decision, and the contractor shall follow the order, the conditions which is published by the concerned office PHE, Hills Division Channel, and also to work together with the VWC, SC of the 4 villages, and he should work diligently according to the given plan and guideline. We kindly request to accept the contractor, and we have selected so that the work must be taken forward. So this was the letter given by the 4 villages, and signed by my lord here. Though they have mentioned 4 villages, 3 villages have signed. Signatures available in page number 141, my lord. And yes, thereafter, my lord, page number 142. These 4 villages have collected, my lord, some amount from the writ petitioner as to contribute 5% of the, page number 142 is the receipts, my lord. May I just read out, my lord. The amount to be paid to the VWSC by Sri Mr. Jun Lingdo will be rupees 2,50,000 only in advance, given rupees 2 lakhs only. Balance amount, the money will be received through check. So this is a contribution towards the 5%.
5% has been done by the petitioner himself.
Yes, yes, he has contributed.
The community contribution.
Right. So that these people will contribute to the given to the government. So this is the exchange. And thereafter, my lord, this contribution, my lord. Thereafter, the page number 144, the writ petitioner, my lord, since endorsed by those, recommended by those villages, he has written this letter to the executive engineer. Issuance of work order in respect of, my lord. With respect, I have the honor to inform you that I have been selected by the Joint Action Committee, VWC, such, for doing the construction work on the scheme, Jal Jeevan Mission on the village of such, as per the resolution passed by the such. Therefore, you requested to kindly issue the contract work order of the said scheme on my name at the LS for your kind consideration and such. So he requested, ma'am. And nothing was happened.
It was dated when?
This date was letter was, my lord, 27/1/2022, my lord.
This letter?
My lord, this letter.
It's not indicated anyway.
My lord, Lordship, kindly see page number 144A, the next page, my lord.
Where the date? 27/1.
My lord.
27/1.
27/1.
Okay.
And since nothing was happened of the payment of this 5%, therefore he sent this letter.
He paid the 5% to the government.
Madam,
they accepted it.
Madam, 5% is supposed to be handed over by
the community. Yes.
By the community.
And so he paid on behalf of the community.
Yes.
Okay.
Now, therefore, nothing happened. Therefore, he has written this letter to the village communities, page 145.
Yes.
It says, my lord, with respect to subject of mention above subject, I, the undersigned, would like to put forward this complaint as to why the work order of the scheme Jal Jeevan Mission is not yet issued till date, even after the recommendation of your committee and your approval. I sincerely have to make known to you that the scheme is being implemented everywhere now over the state for the benefits of the common people, and perhaps it is a central scheme which already has a sanction. I have also to make known to you that I have already spent so much personally to initiate some preparation right after you have recommended by my name, and I'm ready to implement the work too as the earliest. Kindly give clarification if at all there is any alteration from your side or changes in the recommendation, because I have no knowledge if there is anything as such. Therefore, considering the public benefit and rights, I do hereby seek clarification from your side whether the committee has changed the recommendation or any higher authorities stay the project for personal benefit or interest, or the office of the EE Mausaram Shillong has any objection which is not clarified to me. Kindly answer. So he has written this on 4th February, my lord. 4th February. There were, my lord, the allegation of, my lord, the page number 146 allegation of that leader notice was issued that they asked for 10%, right? The next page, Your Lordship, kindly see, page 147. 47, my Lord. Point number 4. He says that the main reason for refusing to issue the oversight work is because my client refused to pay bribe to you and to the MLA till date. So the counter.
Very aggressive lawyer.
This was my Lord. This was
a legal notice.
My Lord.
These kind of allegations.
My Lord. This was happened, my Lord.
I mean, it's not been denied. No defamation case has been brought against.
But
no.
No, that luckily, my Lord, that was not happened. And moreover, Lordship, can you see page number 149? 149. Another legal notice was issued to the MLA with the same similar kind of allegation. And therefore, my Lord, the page number 151 reply to the legal notice was sent, my Lord, by the executive engineer. My Lord, may I just read out this important, my Lord. Reply was 10 February 2022, legal notice. It says that with reference to the subject, I have the honor to inform you that the question of issuing work order to Sri Mr. Jun or any contractor for retrofitting our such combined water scheme at this stage does not arise as the following office procedure yet to be initiated. Madam. Number 2, may I take, madam. After procedure of punishable I have completed, tendering process will be started. So they are talking about the tender process. And at the bottom, therefore, Sri Mr. Jun may be sensitized and make to understand the basic office procedures. So this was the reply of the EE, madam. EE. And my Lord, the reply was given by the MLA, my Lord, page number 153. 153, my Lord. Yeah. 153. This was my Lord.
153.
153, my Lord. 153, you say, my Lord. But there is another. Yeah, this is more or less the same. May I just come straight away to page number 156. This is a reply given by the lawyer of the MLA. 156. So they denied. They denied the allegation. They denied.
Naturally denied. They'll say yes. We asked it for bribe. You didn't pay.
Yes, exactly. Right. They denied, my Lord. So with regard to, my Lord, with regard to sanctioning of the project without tender process was made the end of there. So no matter he has deposited, he has given that.
What about the fitness of the contractor? Does not be examined by the state respondents?
My Lord, that is the scheme. Therefore, yes, I read out that relevant portion. The
scheme is okay, fine, yes. But then, like, what is the suitability? I mean, the communities implemented themselves. But now, why the issue tender is?
So that not in this area, other area also, directly the department used to sanction and through the village level to implement it. Therefore, they expected that one, but nothing happened. So because of that counter allegations, made the end up there. Now, department proceeded for the tender process in accordance with law. So we have disclosed this, my Lord. It is our duty. We are invoking the jurisdiction. If we don't disclose this, my Lord, that amounts to separation of facts. We are not really seeking relief from these exchanges, my Lord. So we are disclosing the background. Now the core issue in this writ petition is now the tender process, the fairness in tender process. Now tender is, my Lord, page.
So you are accepting that you go for tender?
My Lord, yes. And I participated. We have participated, my Lord. Page number 158, my Lord.
What's happened now to the work?
My Lord.
It's stuck.
This is stay order.
My Lordship has given some status quo order because of the fairness of the tender was questioned in this writ petition, my Lord. Page number 158, my Lord. This is a tender, my Lord. NIT. May I just read to your Lordship permission? Seal tender affixing non-refundable court fees, such as mentioned below, again the following work eventually to be drawn in such are invited from the registered class 1 contractors of PHE. The Meghalaya for 2021-22 and received by the undersigned up to 3 p.m. on 22nd such. The tender will be open on the same date and same in presence of the intending tenderer or their authorized representative who would like to be present. If the said date happen to be a holiday, next working days may be deemed as the last date for receiving and opening of the tender. The detailed tender papers forecasting the papers and other particulars may be obtained from the office of the undersigned during office hours and such to such up to such on payment as mentioned below. The department does not bind itself to accept the lowest rate and reserve the right to accept or reject any of all tenderers without assigning any reason thereof. Now, 3 packages are there, 3 items are there, my lord. Number 1, providing profiting up to, my lord, FHDC means, my lord, functional, my lord, functional household debt collection. The abbreviation of this, my lord. At multiple Mountain Pidao village, my lord. Combined water. This is one of the village. It's considered as package number 1. Amount is also mentioned, my lord. Second is providing such and such, my lord. The same village is a package number 2. Amount is 23 something. Now the number 3 is another village, providing such and such at Maukenjing village. So these are the three items, my lord. 3 items with different tender value. Now the next page, Lord, can you see page 159, terms and conditions. My lord, it says that the intended contractor has to acquaint with the work or location before casting the tender. The rates are to be quoted on a flat percentage basis that is above or at par the schedule of rates. The rate would be quoted clearly, both in figure and words. Any cutting or overwriting should be a signatures of the tenderer, else the same. But we are concerned, my lord, recommendation of the VWAC is mandatory. So it is mandatory, my lord. Mandatory. So all the other criteria, my lord, perhaps all the tenderers are qualified, including the petitioners. So 3 participants were there. I have also submitted on 22nd itself, awaited for the opening. And it was not open, my lord. Therefore, I have made a specific amendment in my writ petition. Lordship, you kindly see in my amendment page number, my lord. May the lordship attention to, my lord, page number 17, my lord.
Of your petition?
My lord, yes. My lord, para 16, page number 14, my lord.
14?
Page number 14 and 16, relevant para is 16. May I just read, the
page number
14. Number 14, madam. May I just take it, para 16.
Yes.
As per the tender notice sunset, it is clearly stated that the tenders are to be opened on 22nd March 2000 itself in the presence of the intending tenderers or any authorized representative. Therefore, the petitioner himself was waiting in the office of the said respondent number 6 for participation in the opening of the tender. The staff of the respondent number 6 had told him to wait till for some more time as the tender would be opening in the afternoon, but he was never called. Both the private respondents were also not come or present in the office of the respondent number 6 on such throughout the day. Therefore, the petitioner left the office late evening with the expectation that the respondent number 6 could not open due to paucity of time, or otherwise with the further expectation that they would be intimated the next day for opening the tender. Number 7 also my take. However, the petitioner was informed by respondent number 4 verbally on the next day that respondent number 6 had already opened the tender on sunset itself without the presence of all the tenderers.
So none of the tenderers are present?
My lord.
None of them are present?
None of them were present.
Okay.
None of them are present. They were being agreed with this, my lord. We have filed this petition. Now the affidavit filed by the respondent, they have filed 2 affidavits. I take the first affidavit filed by my friend, filed by respondent 1 to 7. My lord, they have admitted that yes, the recommendations are there. Recommendations are there, my lord. May I just take a para 4, para 5, para 8 of the affidavit.
1 second. This affidavit is 18 May.
82. 18 May.
Para?
Para 8 May.
Yeah.
Para 8. The ending part of para 8 may I just read at the bottom. That in the instant case, the village water sanitation committee, at the bottom, my lord, I just lifted from the bottom, my lord, in the ending part, in the, my lord.
I don't, where are you reading from? Oh, in the?
In the, my lord.
It starts from in the unit.
In the instant case, the village and water sanitation committee have recommended 1 or more PHA first conductor for implementation of the work and have handed over the said project to the PHA department, such and such. So they admitted that yes, recommendation is required. Now page number, my lord, the para 10, it says, my lord, para 10 says the government to the para 7 of the writ petition is admitted to the extent that JSC has held censorship. It is denied that the writ petitioner was unanimously selected by the joint action censorship to be the conductor of the project by resolution censorship addressed to the censorship annexure 3. On a clear perusal thereof, it is evident that the representatives of the village and water sanitation committee.
So they doubt your what do you call it, your selection.
My lord, they say that, my lord,
your recommendation.
My lord, in my recommendation, we said 4 villages recommended. In the affidavit they say that no, only 3 villages have signed that recommendations.
Yes.
Yes, and the NIT is with regard to 2 villages, and 2 villages, my lord, definitely signed in the recommendations. So they just pointed out that since we take the plea, 4 of them, they point out that no, not 4, only 3 of them. 3 of them. That is the claim.
So this is, in this case pertains to 4 villages.
Yes.
You mean so. Okay.
Namely, so they say that not all the 4 villages were signed. Now, admittedly, other private respondents, admittedly for them, only one village is signed. It appears. Now, another para, may I take my lordship, page number, para 16, my lord. Para 16. This will be is a substantial reply to my contention. Para 16.
Yes.
May I read my lordship petition? That in response to the arguments made in para 15, 16, and 17 of the writ petition, the answering respondents state that the documents of all the participating bidders were found to be valid. All of them are valid, including recommendation. And in order, as per the tender requirements, including the documents of the instant petitioner, it is noteworthy to state herein that notice inviting tender indicates that tenders will be open on the same day and same time in the presence of the intending bidders or their authorized representative who would like to present, and does not anywhere states that tenders have to be open in the presence of the participating bidders. However, on 22nd March 2022, the concerned officer, respondent number 6, waited for the participating bidders, but none of the bidders or their authorized representative turned up for the said purpose, and it was only after waiting for approximately half an hour, the concerned officer, respondent number 6, opened the bids at around 3:30 p.m. in the presence of the divisional account officer, a technical branch clerk. After preparation of the tender index, the documents were handed over to the technical clerk entrusted with the task of preparation of the comparative statements, and thereafter the comparative statement along with all the documents of the participant tenders were forwarded to the additional chief engineer, that is point number 4, for further necessary actions such as rejection, approval, allotment, or being issuing of work order to the successful tender. It is also pertinent to state herein that as per the not inviting notice tender, or as per existing CPWD manual, which the PHE department also follows, there is no rule prohibiting opening of tenders when the bidders themselves have chosen to remain absent. The entire procedure was conducted as per the standard procedure. It is also pertinent to state herein that the other tenderers, along with their tender documents, enclose individuals and fresh recommendation by the village and water such is also in accordance with the Charitable Commission such. So they have admitted, ma'am. Now only they have pointed out that they say that the tender was open, nobody turned up. Anyway, ma'am. But the substantial point he has pointed out here is that executive engineer is the accepting or not the accepting authority. He said it is the additional chief engineer. So therefore he opened the tender, clearing the performing the clerical jobs, assessment and others, and he has handed over to the additional chief engineer for acceptance. So perhaps, my lord, it is not spelled out in the tender. Normally it was supposed to be spelled out.
Now what does the comparative statement say?
After comparative statements, it says they did not spell out further.
Or 2 villages. This is Madan Bitao and this is. Okay. Yes.
And para 7, my lord. Lordship may take pain to see para 17 with me, ma'am.
17,
ma'am. Statement made in para 18 and 19 of the writ petition is denied. It is stated that it is inaccurate for the petitioner to claim that he has the recommendation of village and sons of 4 villages. The petitioner has actually submitted letter of recommendation of sons held on such, but signed by 3 representatives. So they admitted Only 3.
No, but one thing I just now cursory glance is that 2 contractors were recommended by the village, not only 1.
3, my lord. According to me, I was recommended, but the version of the department is that 3 were recommended.
Yes.
Me, my lord, signed by 3 villages, and other 2 respondent was 8 and 9. One village recommended. Now, in fact, my lord, when the villages combined together, they cannot form a separate committee. They can make a combined committee normally. But here, my lord, each committee has formed and signed it. It appears, my lord. Now, we can see, my lord, the plea taken by the respondent. Now, for fairness of the procedure, my lord, I don't have a vested right for obtaining the contract, madam. It is the law, madam. But what we entitled is the fairness. Now, the NID did not spell out that the executive engineer is only the, my lord, procedure, is the officer to open it and process, and final acceptance will be taken by the additional chief engineer. They did not spell out. Therefore, we have the honest impression, along with others also, that the executive engineer is the one who can open and has the power to accept or deny. But here, my lord, the affidavit spells out that executive engineer has no power. He just simply opened it. In fact, this is a rarity in nature. But without authority, he cannot touch, in fact. But he has touched. He opened it. He admitted. Then after assimilation, assessment, file was forwarded for acceptance or rejection of the additional chief engineer. Therefore, since he doesn't have, my lord, he did not reject any one of us also. But he has seen the documents of all the 3 contenders and said all the documents are invalid in order. So he has forwarded. Now, we just take the recommendation of these 2 gentlemen, page number 32, my lord.
Of the affidavit?
Of the affidavit. My friend. Page number 32 is the recommendation of the respondent number 9, my lord. And type copy is, my lord, page number 33. My lord. Mr. Sansan was recommended. And now, one peculiar fact may I point out, that there is no date of recommendation, my lord. No date of recommendation. I don't know how it was broken. And Lordship has issued notice to them. They are supposed to come and contest or whatever, respond it, but they do not come forward. So date is not reflected. It's questionable. Lordship will keep in mind. And the respondent number 8 is page number 34 and 35. And this is signed by Maukenjing. Another one is another village. The project is only in 2 locations only. So signing up by the 4 villages or 3 villages doesn't matter. But once minority is signed, recommended by 2 villages, it satisfies the requirement of recommendation. So Maukenjing village has signed, but no date.
No recommendations by the villages one.
My lord.
How chairman, headman of the.
It says, my lord. But when they recommend it, we don't know. We don't. So this is quite.
What happened after that?
What, my lord? So they are relying that this is done, so we process and forward it. And my friend has sought the liberty to file another additional affidavit where Lordship has granted, and he has filed additional affidavit dated by 29/6/2022.
Yes.
Here he has further expanded his contention. May I just read paragraph 4?
Yes.
Paragraph 4 that he said, my lord, the incident respondent state that the office of the executive engineer BHE, Shillong Sanzazan, on 9 March, short of the tender, which is Sanzazan, was issued by the executive BHE Sanzat Shillong, where it was indicated that tender will be open on the same day and same time in the presence of intending tenderers or their authorized representative who would like to be present. In addition, he said, my lord, to the tender notice for incident response state that BHE, my lord, follows the CBWT manual notified by the government of India. It is stated that Section Sunset deals with the provision for opening of tenders, which provides that the tenders are to be opened in the presence of intending tenderers or their representatives who would choose to attend at the time and place which would be advertised and such. They have quoted, my lord. We just take number 1. All the tenderers would be open. Tender will be open in the presence of such intending tenderers or their representatives as may choose to attend at the time and place which would be advertised. Now, number 2, my lord, Sanzat would be encouraged to be present at the time of opening of tenders. The tenderers should also be encouraged to be present at the time of opening of tenders. My lord, my respondent is annexing this So downplay that the attendance of the tenderer is not that mandatory, is not required. Not required. So according to me, my lord, the fairness is maintained when tenderers are participating. So he is relying on. And another page, my lord, my friend has taken the para 5, my lord, of the para 5 of the page, same
Yes.
page. Para 5, it says, my lord, answering respondent states that in the short tender notice, since issued by the EE, the category of work was divided into 3 packages, each package having different tender value, and as such, the work order was to be issued as per the tender value only after completion of the formal procedure in this regard. For written reference, the tender value of such and such, he has reflected. And the next, at the bottom, he said, it is stated the government of Meghalaya by finance establishment notification such and such. Meghalaya Delegation of Financial Powers, Amendment 2021 on sunset. Rule 2 of the said amendment provides for citizens wherein specific powers delegated to different departments in the state came to be substituted, and particularly in respect of a PHE, 3 existing entries under 4, 5, and 13 were substituted for ready reference and such a matter. May I take, my lord, to serial number 13. So here, my lord, the respondent is building up the case that respondent before has the competency to accept the tender. Now, chief engineer / additional chief engineer, the up to 30 lakhs. Superintendent, my lord, engineer 15 lakhs, and executive engineer is only 6 lakhs. So they are saying that this tender, though it is floated by executive engineer EE, it has to be accepted by the additional. Okay. So that one is there. Now Now the admitted fact here that Lordship may kindly take have a look with my prayer.
So what do you want?
My lord, therefore Lordship, I invited Lordship attention to my prayer. My prayer number 1, page number 18. He said, set aside and quash the decision actions.
That means there's no decisions have been arrived at.
Decisions to the extent of he opened it and he forwarded it. So it seems that
how is opening it by himself affected you?
Therefore,
if the clause says that if you choose to be present, okay, if you're not there, fine.
Now, therefore, my prayer, since we had the impression at the time of filing that he has the power to reject or approve also, therefore, we question his competency. Now, he admitted in his affidavit that I'm not the approval.
But he has given a delegation of financial and other powers,
yes,
which says that for contracts which are above this one, he has no competency to open or reject whatever.
Yes.
Yes.
Right. Therefore, he has no power.
He has no tenders.
Yes. Even he has no power to open also.
So what will happen then?
Now,
what situation do you envisage in view of the fact he's already opened them? He's already opened them, correct?
Therefore, my humble prayer, Lordship may mold the relief by directing the additional chief engineer now to decide, to select the tender.
That will be the natural corollary.
Yes, within a time frame. Otherwise, they cannot indefinitely keep it pending. It's a public project for the village areas. Now, 3 of them are there. I pointed out
money must have lapsed by now.
Madam?
Money is still there for implementing the project.
It must be still there, madam. It's still there.
It's not lapsable.
It is still there, madam. So for fairness of thing, madam, since I invoked the jurisdiction, my prayer should be reasonable also. In view of the circumstances and the facts spelled out by my friend, that in view of the financial delegation of power, the additional chief engineer has to take a call, and select the competent tender within the time.
Yes, Mr. Sen.
Well, it's a writ petition. I don't know why it was filed then.
Yes.
There is no purpose. It has just stalled the proceeding.
It cannot be.
This was filed in 22. It has just stalled the proceeding since the stay order. They were praying for the stay order. Kindly see what has happened. They start off by saying that as per the JJM guidelines, a recommendation will entitle them to start the work. There is no requirement for a tender process. Thereafter, they issue a spate of correspondences to the respondent number 6 in the MLA saying and alleging that you have asked for a bribe because I did not accede to your request for a bribe. Therefore, you've started the whole tender process. But that is not the challenge in this case. The challenge in this case is the tender was not opened in their presence. We are saying that's a disputed question of fact. We are saying that we waited till 3:30. They were not present. As a result, this was opened. And if they have adequate notice of the time and the date of opening of the tender, if they deliberately abstain from being present, the department cannot wait for this. Now, just for a moment, just glance at their prayer, my lords. I'm not going into the merits of this matter.
Yes.
The entire case was infructuous from the word get-go. Kindly see, they're asking for setting aside the decision of opening the tender. Tender has already been opened.
Yes.
Lordships have already seen the comparative statement that has been prepared. They can't be prejudiced by that. Everybody has quoted the base price.
At par.
And next, at par, my lords. So they can't be prejudiced. Unless they say that there was some other event that took place while opening the tender, somebody who was not actually suitable, they have made some entries. That is not their allegation here. And the next prayer is to reopen the tender. We'll agree to that. What is the ground reality of this? Which means we'll have to reseal the tenders and open it all over again. That is their prayer. And these kind of prayers cannot be granted. What they're asking for is for molding the relief. I anticipated that, my lords. So I have a decision of the Honorable Supreme Court on this issue that unless and until there's a specific prayer.
Is that if the community cannot implement it itself,
Lordship,
then it reverts to the PhD department to issue tenders.
Lordship.
And in this exercise, there will be some recommendation from the villages also.
Yes.
That there is a suitable person to do it. And then tenders are floated, and these persons who have been recommended only will be considered.
Will be allowed to participate.
Okay.
There's another interesting aspect. He's completely misconstrued this whole issue of contribution of 5% and 10%. The contribution is to be made by the village committees.
Not by the contractor.
He's not supposed to pay.
No, he's not supposed to pay. That is a
that
given.
we feel
That's
it is more of a bribe.
He feels that that 5% is like the booking amount for the contract, which is not cannot be the case.
Cannot be the case. So they are themselves guilty of questionable
That's
conduct.
how it works. So he didn't pay the 10,000 to the MLA. As per the, you see, even the legal notice is very.
So if my learned senior friend is not pressing for setting aside, that's not their prayer for setting aside the entire tender process, then that the consequence is very simple.
What is the judgment?
Lordships, will kindly have that. Kindly have page 246.
Yes.
Para 29, Lords.
Yes.
It reads, the approach of the High Court in granting relief not prayed for cannot be approved by this court. Every petition under Article 226 of the Constitution must contain a relief clause. Whenever the petitioner is entitled to or is claiming more than one relief, he must pray for all the reliefs. Under the provisions of the CPC, if the plaintiff omits, except with the leave of the court, to sue for any particular relief which he is entitled to get, he will not afterwards be allowed to sue in respect of the portion so omitted or relinquished. Though the provisions of the code are not made applicable to the proceedings under Article 226 of the Constitution, the general principles made in the CPC will apply even to writ petitions. It is therefore incumbent on the petitioner to claim all reliefs he seeks from the court. Normally, the court will grant only those reliefs specifically prayed for by the petitioner. Though the court has very wide discretion in granting relief, the court, however, cannot, ignoring and keeping aside the norms and principles governing grant of relief, grant a relief not even prayed for by the petitioner. In Krishna Priya Ganguly, overlooking the rule relating to grant of admission to postgraduate course in medical college, the High Court, in exercise of powers under Article 226 of the Constitution, directed the Medical Council to grant provisional admission to the petitioner. This court set aside the order passed by the High Court, observing that in his own petition in the High Court, the respondent has merely prayed for a writ directing the state or the college to consider his case for admission, yet the High Court went a step further and straightway issued a writ of mandamus directing the college to admit him to the MS course and thus granted a relief to the respondent which he himself never prayed for and could not have prayed for. Again, in Om Prakash versus Ramkumar, this court observed, a party cannot be granted a relief which is not claimed if the circumstances of the case are such that granting of such relief would result in serious prejudice to the interested party and deprive him of the valuable rights under the statute. Now, I believe my learned senior friend is not asking for setting aside the tender. And what he's simply asking for is for the respondent number 6 to evaluate the tender and pass an order on grant or acceptance.
No,
so that would have been the natural consequence in any case.
Natural consequence, nothing contrary to any tender procedure. If, as per the second affidavit, it says that, then what remains?
Nothing remains in there. It was infructuous right from the start.
No, my lord, here they said that the power is vested with the additional chief engineer. Now, additional chief engineer.
So are you questioning now, reverting back to argument that the opening of the tender bid, the tender papers by the executive engineer is totally out of jurisdiction?
My lord, therefore, I'm not.
So then will you have to? And the thing is that what we cannot court cannot ignore is that all the bidders submitted at par.
My lord, at par now. Therefore, my lord, I'm not seeking for setting aside the decision taken or action taken by the EE. He has taken already.
Fine, then.
Now the lordship may be kind enough to direct the additional chief
Of course,
engineer.
then he can
take a
withdraw
final
it
call
and then
within
we'll
a
just
specific
make observation.
My lord, it cannot be left with the sweet will of the respondent. Now here,
No. We'll say we'll close it with the direction that, as per the second affidavit, we'll allude to that, and then we'll say that in view of this position, the relief that the petitioner had initially sought, doesn't seem to have any, what do you call it, force any longer. Because you are under the mistaken assumption that the executive engineer is the competent authority to open the tender bids and also to decide on the successful bidder, correct? But then by the affidavit it transpires that that's not the case.
But no,
so now that so what is be the fate reputation? Number one, you think about public interest is a matter involving water supply in a village.
Well, therefore, the prolonging will affect the water.
Prolonging will affect everything.
The judgment relied by my friend. If third party right is created, it will be affected to other parties.
No, we're not looking at the judgment.
It's just not affecting anyone.
What Mr. Sen shows only that if it's not prayed for, whether the court can mold relief. But court can mold relief. It's 226.
I don't need to
so that's
trouble
the thing is.
I don't need to trouble that one. Now, only my prayer, my lord, since it is involved public interest, 3 tenderers are there. Competent authority has to take a final decision. Yes. Therefore, lord should be direct the respondent number 4 to my lord to take a final decision within time frame. I have 2 more judgments, but I may not take a lordship further time.
The instant matter concerns a short notice inviting tender for implementation of what project is it called? Where's the tender?
It's at page 158. It's a retrofitting up to FHTC.
The instant matter concerns a short notice inviting tender for implementation
of a project for where's the retrofitting?
It's mentioned in the columns in the name of works.
Is for
implementation of project.
No, for retrofitting for in Madan Bitaw, MADN BITAW combined WS water supply scheme.
Logic.
Yes, combined water supply scheme stuff. Short notice by tender dated 9/3/2022 stuff. These are projects under the Jal Jeevan Mission, a scheme wherein community participation is called for in its implementation. Stop. However, in case the villages by itself cannot implement the scheme, the concerned department was to execute the work. Stop. It is in this backdrop that the above short tender notice was floated. So, the grievance of the writ petitioner is that, apart from other issues dealing with recommendation and tendering of the 5% amount and tendering 5% amount as stipulated by the scheme is that these tenders, the tender of the bidders were numbering how many number? Numbering three number were opened by the respondent number number 6 in their absence. And as such, there's apprehension, and the apprehension has been that, and as such, there's an apprehension by the petitioner that the tender process not being transparent has been vitiated by the absence of the bidders. A prayer has been made. Next para. A prayer has been made. The prayer made in the writ petition is for quashing any decision of opening or any unilateral decision of quashing the decision action of prayer. I can't get it. Setting aside quash decision action of opening taken or unilateral decision of opening a tender. Just right.
The prayer made in the petition is for quashing any decision
of taken by respondent number 6 pursuant to the opening of the tenders. With such as reso, next paragraph, let us see a council with so and so. Submits that at this stage, however, on the affidavit filed by the state respondents, which indicates that, where is that? Where is that affidavit?
Affidavit Madam 29/6/2022.
Yes.
Additional affidavit. Madam.
Yes.
Mr. H.O. Shingoso on the Let's Make Council assisted with Shingoso submits that at this stage, however, on the affidavit filed by the state respondents, which indicates that
Para 5, madam. Para 5.
At para 5. Which Thomna?
submits that at this stage, however, on the affidavit filed by the state respondent, which indicates that
which at para 5 has detailed the government of Meghalaya, has detailed the Meghalaya delegation of financial powers, all capital name, within bracket amendment rules 2021. Where is given additional chief engineer or the additional chief engineer stroke additional chief engineer is the competent authority on opening of tenders to settle the bids. He submits that as the tenders have already been opened, what remains is only for the finalization of the bids by the additional chief engineer. Stop. Next paragraph. Mr. S. N. Leonard, senior government advocate, appearing for the respondents, submits that the writ petition has died a natural death, inasmuch as the prayer as sought by the writ petitioner at this stage cannot be the relief sought by the relief sought by the petitioner, the prayer cannot be is not possible. He further submits that the relief as the relief prayed now, which amounts to molding the relief, cannot be considered by this court. In this regard, the court of judgment, the senior GS place the following decisions. Next paragraph. Appellate counsel for the parties, from the submissions and materials on record, the fact that the tender has since been opened cannot be disputed, as also the fact that the work is yet to be settled with any of the bidders. Stop. The apprehension of the writ petitioner, it appears, is based on the understanding that the executive engineer who had opened the tenders was the final authority in settling the bids, and not being present at the time of the bid opening, feels that he has been unfairly treated. It is next paragraph. It should be noted that this project is in public interest and involves the water supply to the concerned villages, for which no further any delay will be to the detriment of the villagers. Stop. In this view of the matter, therefore, without going or delving into the facts and materials of the case, this court deems it fit to direct that the bids which have been tendered be proceeded with, or the bids have been settled be finalized, or the bids that have been
This court deems it fit to direct that the bids which
have been submitted and since opened be settled finally by the competent authority, that is the chief or respondent number 4, by the respondent number 4, and to award the works in accordance with law and the bids as provided. Stop.
If Lordship give some time frame indicates.
Yes, it is expected that as the project, as noted earlier, As a project of public interest, it is hoped that the matter shall be dealt with expeditiously, preferably within a period of 4 weeks from the date of this order.
Highly obliged.
I do. With the
I just crave Lordship's indulgence with regard to another matter. In the supplementary list in item number 5, Lordships had recused from that. I've made a prayer in court number 2, but the 5 will have to be sent. Today is the last date for the notice.
The file will go automatically?
No, it's still here.
I believe that I can't pass orders to that effect.
Lordship, we'll just...
Yeah, we just have the file.
If the file can reach the court and the court has stated that he has been
Okay. It's with the registry.
The court will, that our concerned court will call for the file.
Lordship.
Have you mentioned it there?
We have. I was under the impression the file is still here.
No, once it's gone, it's gone. It's gone.
Highly obliged.
Yeah.
Item 20.
May it please your lordship? Your lordship, I pray if this matter can be taken up at the end of the board.
We already ended the board. Yes, you ready?
Your lordship, he's still on legs.
Who?
Before courtroom 3, your lordship.
Mr. Guru or Mr. Dr. Mozika?
Dr. N. Mozika, your
Where's
lordship.
Mr. Guru?
Yeah, he's still on edge in the courtroom 3, your lordship.
After some time, because before 1:30. Yes.
21.
May I please, Your Lordship? Your Lordship, in this matter, actually, Mr. Raichaudhary is from Guwahati, so I'm seeking actually on his behalf for 4 weeks' time, Your Lordship. He's not well, actually, he not come today.
But Mr. Depp was appearing. Who's Mr.
Piquet?
This Mr. Raichaudhary never appeared. Let us see when he appeared.
I don't know, just...
P.K. Raichaudhary.
Piquet, right?
He's not here.
Over telephone, he informed me, actually.
None appeared. I think Mr. Raichaudhary appeared only once at the time of motion.
Maybe. This morning, so actually, telephone.
We can't give that kind of concession waiting for getting the hearing list. What's the matter about?
This is for service matter, I think so.
You think so? Yes.
Maybe please want it, my lord.
When is it possible for hearing to see? He didn't appear anymore. Yes, prayers may be held as a P.K. Raichaudhary, who stated to be not available until long today. This is matter of the 6 weeks. Yes.
23.
May it please your lordships. Now, my lord, this is a matter, if your lordship recollect, almost, my lord, over 3 months before the matter was substantially heard. My learned friend
3 months before that court.
No, my lord, only thing I am pointing out, lordship, my learned friend almost concluded the submission. Then, my lord, confronting with certain queries, he sought, my lord, some time to file an additional affidavit. My lord was also generous to grant him 3 weeks time. That 3 weeks it was never filed, your lordship. Thereafter, repeated time was sought. On the last occasion, my learned friend made a submission, it will be filed in the course of the day. My lord, just half an hour before he served a copy on me. So he deliberately created a situation for adjournment, my lord. This thing cannot go on, your lordship. Now, how can I do it, my lord? Just half an hour before I have received.
I filed it
This
this
is
morning.
a very casual approach, my lord. Very, very casual approach. Very unfortunate.
I filed it this morning, my lord. Not happened.
Lordship will see the last order.
1 week further time. 11/7.
Yes, my lord.
Can't help it. These are the speed breakers in the course of justice.
This is a very, very casual approach.
If my senior wants to take up the matter, I have no problem.
But half an hour before your lordship, how can I do it?
Sen for the trouble he's been.
My lord, it's not half an hour. That is not correct, my lord.
Half an hour before. Half an hour or 40 minutes before your lordship.
Oh, you take your disputes outside.
My lord.
An affidavit has been filed by the state respondent city itself, which Mr. Essence prays that some time be granted to enable him to examine the same. Yes. When? This matter?
Any day on that.
She'll give the date on so and so. Is that revision of pay scale?
No, not exactly revision. Entitlement of, my lord, promotional increment on introduction of UGC.
They're basically on increment, my lord.
Yes.
If your lordship please, it can come up next week also.
We have clock now, Mr. Senator.
Or next to next week, man. We'll complete it.
She'll give the date.
Oblige.
24.
Oblige.
May I please, Your Honor, I'm appearing for the petitioner. Your Lordship, my senior is not available to be here today, Your Honor.
Who's the senior?
DK Wadri. So, Your Lordship, if you can
Last time also, are you MS Kading though? No. You are?
WL Nongri.
What's the matter about? Not your salary.
Salary, not regular pay. They're claiming for regular pay, the post is not a sanctioned post.
Equal pay for equal work. Yes, you don't know urgency in the matter. The praise will be on behalf of Mr. D.K. Walchi, who is not present today. So, accordingly, the prayer for adjournment has been made on behalf of the body. It's not present for today. This is a matter of 3 weeks. It's 22 matter.
Really oblige.
26.
Yes. Yes. What's the matter about? Short matter or long matter?
It's a service matter, Lordship. It's I'm praying for grant of disability pension, and I'm covered by division bench order of this Honorable High Court only. So,
what is the extent of disability?
40%, Lordship.
40% is covered?
Covered, Lordship. The minimum is 20%.
Your Lordship, if we come to our affidavit in opposition, if we come to page 3, paragraph 4.
Yes.
The 10th line where it's written in terms of rule 9.3 of the CCS extraordinary pension rules 1939, the petitioner's disability was declared to be 40% only, while on contrary, to be eligible for disability pension, the petitioner's petitioner disability should be declared at least 60% by the invalidating medical.
Lordship, if I may, Lordship. Lordship,
if I rejoin to this?
No, Lordship. I'm not.
Why?
Lordship, if I may, Lordship, this 60%, if I may, Lordship, I'll start from the beginning. I'll do a brief background of the case, Lordship. Lordship, I was enrolled in Assam Rifle in the year 1986, Lordship. And then while undergoing training...
1986,
Lordship.
Okay.
While undergoing training at 9 GTC, I suffered a disability, Lordship. And then I was subsequently discharged from service on 1st April 1988, Lordship. At the time of discharge, I was instructed that I'm entitled for disability pension, and then I would be getting it.
You joined 86, then when did you suffer disability?
During the course of training, after 2-3 months, Lordship. Then I was instructed that I would be getting my disability pension. And these, the respondent have admitted as much as recent as 2020, Lordship, that I'm entitled, and they'll be processing it. If Lordship can come to page number petition. Page number 2, Annexure 8, page number 43 of my petition, Lordship.
Annexure 8?
Annexure 8, page number 43. The type copy would be in the subsequent page, Lordship.
Yes.
If I may, Lordship, if I read.
Yes.
Please refer to your legal notice dated to 2020, 19 to 2020, para 2, Lordship. On scrutiny of service records of your client, X number this, so and so, recruit General Duty Dharampal Singh, it has been revealed that he had sustained injury, fracture tibia fibula 3rd RT during night parade while attending basic training at 39 Gorkha Training Center, Varanasi. His injury was declared attributable to service conditions. As he was unable to complete his basic training and unlikely to become an efficient soldier due to his injury, was brought under an invalidation medical board as recommended by the specialist, Military Hospital, Allahabad.
Okay,
and
this is dated 18 May 2020. Yes. So, what happened after that?
It is intimated.
Where's the order of rejection?
Lordship, here they have affirmed that I am entitled, Lordship.
No, okay, in reply to this, you said, okay, fine, you've been considered. Where's the order of rejection?
So this is the last.
Yes, page 76.
This is 18 August 2022, page 76, Lordship. Refer to you later, this dated 1st August 2022. As per Rule 3A of CCS EOP rules, the disablement should be attributable to service, and as per Rule 9.3 of CCS EOP rules, disability should not be less than 60% for grant of disability pension. Whereas as per invalid medical board proceedings, disability of your client was assessed to be 40% only. Now these rules have been amended and 60% clause stands removed by DOP and PWID note so and so dated 10th June 2022, which shall be effected to the person who has been medically boarded out of service with effect from 1st January 1996. Since so and so Dharampal Singh was discharged from service on medical ground with effect from 1st April 1988 after rendering 2 years and 19 years of qualifying service, therefore he does not fall under the purview of these rules. So this is the rejection letter, Lordship. Now, Lordship, in the mind of the respondent, there was some.
Yes.
Lordship, and if you can come to respondent's affidavit in opposition, page number 4, para 6, Lordship.
Yes.
May I read, Lordship? Para 6, that there was contradiction concerning the exact date of removal of the condition of 60% disability from the Central Civil Service Extraordinary Pension Rules 1939. Consequently, the matter was taken up with the Ministry of Personal, Public Grievances and Pension, Department of Pension and Pensions Welfare by Director General Assam Rifles, letter number so and so, dated 17th March 2022 for clarification with regard to date of applicability of the Gazette notification. Number this and this dated 15 February 2011. The Ministry of Personal, Public Grievances and Pension. Now, they have attached this note, Lordship, as Annexure 9.
Very confusing.
If you can seek Annexure 9, Lordship, things will be clear.
Very confusing.
There they are claiming that there was some confusion with regards to 60%. Concession of 60% as to the date of concession, Lordship, and they have sought clarification from the higher authorities. Now, the clarification which they have obtained, Lordship, kindly come to Annexure 9.
Page
53, Lordship.
Okay.
Para 2, Lordship. After, this is from Pension Department, the Ministry of Pension, Lordship. Please refer to reference received from Director General Assam Rifles wide letter number so and so dated 17th March 2022 in this department. After examining the above, it may be stated that at no stage the rules provided that disability pension will be admissible for disability of less than 60%, Lordship. This is crystal clear, Lordship. That there was never any condition that minimum.
Where Dr. Majika? Oh yes. What did you say was you appeared magically from somewhere in the CPS?
But the petitioner was boarded out on 1/4/1988, my lord.
Right.
Now, our first submission is, my lord, that is highly belated, my lord. It's coming after almost 40 years, my lord, 35 years.
What are you doing right now?
Lordship, I'm a farmer, Lordship. I was an able-bodied person at the time of entering. Now I'm
that
disabled.
you have to meet that this is the first time you never represented after legal notice. When's the last legal notice?
Lordship, 2022.
The first one, when?
First one, Lordship, I may praise Lordship that I had even approached Allahabad High Court and division bench had
When
rejected
you approached
my...
Allahabad High Court?
Lordship, I had approached 2016, Lordship. If I'm
2016, then from 88 2016, the first time
Lordship, I
agitated.
had been regularly coming over to Shillong Director General headquarters and making submissions, Lordship. And there, I was even given disability pension forms, and then I had filled up that form as well, Lordship. And then this is a pension matter, Lordship, and Honorable Supreme Court.
Is that a pension matter in the sense that if you sleep with your rights, also whether you acquired any rights at all, that is we have to examine first. And number two is your delay. The delay will kill your case, Mr. Pandey.
Lordship, if I may, Lordship, I have submitted a compilation, Lordship. There, one Supreme Court judgment is there, which says that pensionable matters are continuing wrong, and every month
These are continuing wrong in the sense that if you're entitled to it and it's been proven your term benefits are not paid, yes, and if you come for a long time, right. But if your rights have not been as settled as yet, so how can you see it's a continuing wrong?
Lordship, I understand.
For a right that you cannot, you have to establish first.
Lordship.
So is that wrong or is that right?
Lordship, I understand, Lordship.
If you have established your right and a right we have not exercised, then we understand because it's a continuing right, but not a question of we have not established your right and you say it's wrong. Yes. Where have we written where pleadings with regard to the delay in approaching courts or seeking relief? Which paragraph you made the pleadings? In paragraph 3 is that running from pillar to post?
Yes, sir. Lordship. Yeah, Lordship, I've been running from pillar to post literally, Lordship. I've been coming over from UP to DGR headquarters and then making submissions after submissions, and I was told that I would be entitled, Lordship. And then as recent as 2020, I was given a letter affirming that I am entitled for disability pension, Lordship. As recent as 2020.
No, a representation earlier was for reconsideration of your discharge. Sad to see also this judge, he says Director General of Assam of Rifle Shillong in Assam. Yeah, one thing, Dr. Mozika, what do you have to say about the applicability and interpretation of that letter, which is at page 53 of the writ petition? Because the amendments you made in the affidavit do not seem to reflect what the letter says.
But on that, my lord, in fact, I am going through the judgment, there are decisions of this honorable court, my lord, that 60% is applicable in a different perspective, my lord. In fact, my friend is annexed, my lord, as a division bench order of this honorable court.
Where is annexed division bench order?
In the compilation, Lordship.
And give the reported ones.
No, page 53 of your affidavit. Yeah.
In fact, the learned single judge dealt more elaborately, my lord.
Where's the operative part? Which paragraph?
Lordship, if your Lordship is referring to Satyanarayan, Union of India versus Satyanarayan, then it would be para 13, sub para 2. Para 13, sub para
yes.
2, Lordship. For lower percentage of disability, the monthly disability pension shall be proportionately lower as at present, provided that where permanent disability is not less than 60%, the total pension, that is pension or service gratuity admissible under the ordinary pension rules, plus disability pension under EOP shall
Well,
be.
this is the quotation of the GOI.
The next page, Lordship.
The above para 14, my lord, after the quoted portion, the above extract is relevant for the purpose that the ministry has provided that for a lesser degree of disability, the minimum pension limit will be proportionately less. Hence, the stand of Assam Rifles that since the disability has been assessed to be less than 60%, the respondent should not be granted pensionary benefits cannot be accepted. Besides, there is a distinction between invalid pension and disability pension. Again, Ministry of Personnel and so has clarified the position. The CCS pension rules 72 deals with invalid pension, whereas rule 3 of the extraordinary pension rules provide for disability pension, provided that the eligibility to claim pension would depend upon the attributability of disability to service. Thus, we hold that the respondent would be entitled to get the disability pension under the so-and-so accordingly. So-and-so.
Yes. See the 53 of the affidavit, page 53 of your affidavit. I just want some interpretation of this. Where is that? When is that the reply? It's 53 of the affidavit.
Affidavit, Lordship. Yes,
their affidavit, correct?
Yes. Annexure 9, Lordship.
Yes. This clarification sought by the DGAR only. So just read the second para.
After the examining the above,
yes,
it may be stated that no stage the rules provided that disability pension will not be admissible for disability of less than 60%. Earlier Rule 9.3 of CCS COP rules provided that the disability pension, service element and disability element will not be less than family pension admissible to widow under UOP rules. After broadbanding with effect from 1/1/96 by OM dated 3/2000, this provision became redundant. It is not correct to say that the broadbanding mentioned in para 3 of the Assam Rifles letter dated so-and-so came into effect only from the date of notification of the amendment on 15/2/2011. The broadbanding with effect from 1/1/96 was introduced by OM dated so-and-so. Therefore, before 15/2/2011, broadbanding was to be provided in terms of OM dated 3/2/2000 and therefore in terms of amended notification dated 15/2/2011. In view of the
yes.
In view of the word, DGAR is advised that government servants who are boarded out before 15/2/11 with less than 60% disability are also eligible for disability pension based on broadbanding introduced with effect from 1/1/96 wide OM dated so and so.
See, this is
this is one from 1/1/96. Here
it says that the governments who were boarded out before 15/2/2011 with less 60% disability are also eligible to disability pension being introduced with
based on
effect
introduced with effect from 1/1/96. Here's the case of 88, my lord.
Whatever it is, but then 1996, what was the position before that?
Lordship, in my compilation, I've ordered annexed that order. What will happen to the claimant who?
OM.
OM, Lordship, page number 46. There are two OM, Lordship.
You given compilation to him?
Yes, Lordship, I'll give it now.
Where is the relevant part?
Lordship, I'll just read out, Lordship. The undersigned is directed to say that in pursuance of the government's decision on the recommendation of the 5th Central Pay Commission, sanction of the President is hereby accorded to the regulation with effect from 1196 pension, family pension to all pre-1996 pensioners' family pensions in the manner indicated in the succeeding paragraphs. These orders apply to all pensioners, family pensioners who were drawing pension, family pension on 1/1/1996 under the Central Civil Service Pension Rules 1972 and CCS Extraordinary Pension Rules and corresponding rules applicable to railway pensioners and pension all India services, including officers of the Indian Civil Service retired from service on or after 1/1/1973. Lordship, next page is number 47, paragraph 5.2.
You have not been granted disability pension yet, then how will you see this apply?
Lordship,
your case is still under examination.
Yes, Lordship, but then I will be. The question is whether what will, because this the order came into 1996.
5.2, okay.
Where the disability pension under the CCS EOP rules is drawn in addition to the invalid pension under CCS pension rules 1972, the minimum limit of rupees 1275 will apply to the total of two pensions as indicated in paragraph 5.1. Where the disability pension is drawn in isolation, the minimum limit of sum which will be applied for 100% disability. For lesser degree of disability, the minimum limit will be proportionately less, Lordship. And there is one more, Lordship, which will throw more clarity on the matter, Lordship. The another OM, Lordship. Office memorandum dated 29 July, page 58, Lordship, of the compilation.
Page 58.
58, Lordship.
Yes, okay. This seems to have some, yes. Yes, what do you want to show?
Lordship. Para 4, Lordship. For calculating the disability pension with effect from
this will affect from 1/1 to
Lordship, para 3, Lordship, para 3. The matter has been examined and it is clarified that central civil government servants who were boarded out prior to 01/01/2006 with the qualifying.
But this is not applied. You have not. You see, you have not been granted any pensions yet. How will it apply?
Lordship,
you see, if you have two parts, disability and the other pension, then yes, minimum amounts of fixed and how will it apply? But in your case, like this court said earlier, that you yet to still establish your right, to that disability pension. It's very confusing, Dr. Mbozika, that letter.
My lord, 1196 post 1196, my lord.
Why was you post 196? You see, broadbanding that 196 doesn't mean that you just throw out all the old cases. And if you take that analogy, below 60% eligible also, and the judgment is there. How will you reconcile these?
But in these cases, the disability happened much after 96, my lord.
And even in the case
that is only critical date, my lord. Whether what will happen to those who
even this matter passed by Umar Singh?
Yes, my lord. It's 2004 case, my lord.
That's the only thing that goes against Mr. Pandey's client, which is suffering the court, is the long delay. You went to court, but you didn't ask for disability pension. You asked for re-employment. Correct?
Lordship.
In Allahabad, yes.
Lordship. That's true, Lordship. But Lordship may kindly consider the respondents have communicated to me as recent as 2020 that
that
I would be
take into
entitled.
consideration. But how would they apply it? That's the only thing. Because for them, what difficulty expressing is not because of the late you're coming to is how will they apply it if it's not applicable? Like it's only with effect in 1996. The only thing that is so long ago you were boarded out of service.
Lordship,
88 you were boarded out of service.
Lordship, in this judgment, Lordship, the Honorable Division Bench has referred to this. This will, I hope, clarify matter. This order number dated 1/1/1986, Lordship. I've annexed that order also. If we can go through that para 14 of that order, things will be a little clear, Lordship.
Which one? Which judgment?
This Union versus Satyanarayan, Lordship, page number 24 of my compilation, Lordship.
Which paragraph? The one been placed by Dr. Bozika. Which paragraph from this reported judgment?
Lordship, para 7, Lordship.
The revised provisions effective 1st January.
May I read, Lordship? Para 7.
Wait. See the note appended to that too. That's important. Now, what do they mean by, say, for example, if this is only 80%? He says it's not applicable, this para 7. That is only related to amount, not to entitlement. Correct?
What's may I read, Lordship, once more?
This is Rule 49.
Lordship, page number 30, I've annexed the order referred to by...
Very confusing. Page 30?
30, Lordship. I've annexed that order referred to by the London Single Judge, Lordship.
In your compilation?
Your Lordship.
In the compilation. Yes.
Page 30, Lordship, would kindly come to page number 36, para 14.3, Lordship.
Page?
Page 36, para 14.3. May I read, Lordship? 14.3.
Page 36?
36, Lordship.
Para 14, okay.
14.3. Disability element. The rates of disability element for 100% disability for the various ranks shall be...
No, let's come back to the basics. Why are they denying you? We're quoting which rule to deny him the disability pension? You have to go back to the basics instead of reading all these rules. We'll go to grounds of denial and see whether they are... What is the basis of denial? He's impugning only one letter, which is a reply to his reply to legal notice. It's not The court's confused, absolutely.
Lordship, if you can, Lordship, just indulge me and read last line of paragraph 14.3, Lordship, just a bit, Lordship. Provided that where permanent disability is not less than 60%, B, for disabilities less than 100% but not less than 20%, the above rate shall be proportionately reduced, Lordship. This is later dated 1186, Lordship. So
where reading from?
This paragraph 14.3, Lordship.
Or the judgment?
No, sir, my compilation order.
Paragraph
14.3, Lordship. Page number 36 of my compilation.
Oh, yes. Yeah.
14.3, para B. For disability.
Yes, I read it. I've read it. I just want to come back to the basics of their denial. Okay, fine. They have sort of examined your request, but where is the actual denial that you're not entitled? We'll come back to that. I mean, there is categorical denial that you're not entitled to. That's what really matters.
Michael.
We'll come back.
Can I tomorrow, day after tomorrow?
That will next week. Let's see. Any inconclusive this for further hearing after 1 week is. You just come up with some clarification, because the thing is that Mr. Pandey, you're confusing with with the amount and the entitlement. They're two different things.
Lordship.
So entitlement, now you have to show a clear path, by your submissions and by materials, that you're notwithstanding the delay, that 40% disability will entitle you to disability pension. Fixation of amount will come later on.
Lordship, I'm not.
That is proportionately will be fixed if your entitlement is, if you could establish entitlement. And also, Dr. Mozika, on what basis have you rejected the claim for disability pension as well, notwithstanding the delay? What would you do normally in a case of 40% disability as a thing?
There are two pensions, the other pension, invalid pension, 10 years service is required.
But this won't apply in the disability.
So here,
that qualifying service will not be necessary, because he borrowed of service, and he'd be entitled to disability, not invalid pension, to disability pension. There's two different things. So computation of service component and the disability, those are two factors which I take consideration.
Lordship, in that case, only the ground of rejection is 60%. That later itself clarifies that there is no 60% at any stage.
So that is what, on what basis now?
Yes. And
categorical, because that's the reply to your, it's a reply to your legal notice. It's not an order issued by them that you're not entitled.
Lordship, in Satyanarayan case also, the petitioner had suffered only 20% disability.
Otherwise, we might see the for reconsideration, whatever it is.
Yes,
but
cut-off date is also.
The cut-off date also is very confusing, and you will not be entitled to any years, I think, because of delay.
Lordship, yes, Lordship. In Tasrem Singh, the Honorable Supreme Court has held that only 3 years prior to the filing of writ petition would be entitled, Lordship. That
even 3 years, so you won't get.
Lordship, current also will be okay,
Yes.
Lordship.
27.
Yes, Mr. Pathak.
Highly obliged, Lordship. Much.
One of the item 27 and 28, my lord. Both relates, my lord, the issue of pay parity between different paramilitary forces, my lord.
Yes.
Our contention is that the post of rifleman that we are holding, my lord, in other paramilitary forces, my lord, it is equivalent to Havaldar, and they are drawing the rank and pay of Havaldar. This issue, my lord, relates to the Fifth Pay Commission. Some of the cases, Lordship had already decided in the division bench, where, say, for example, in the trade of carpenter, where they are as of now serving in rifleman post, my lord, the equivalent post in other parliamentary forces is Havaldar, my lord. So that issue has traveled to the apex court, my lord, that is pending. That is one aspect of the matter. I believe, my lord, the matter was...
We'll have it after when?
My lord, the apex court said, my lord, the notices are almost served. The matter is coming up, I think, my lord, in the 3rd week of August in the apex court. We can have it after
5 weeks.
4 weeks.
Mr. B. Pathak submits that as the the issue, which issue in question is also on appeal before, it's pending for the Supreme Court. This is matter after 4 weeks. This is matter after 4 years.
My lord.
2 days. Instead, it can be 5 weeks, my lord, maybe.
5 weeks.
5 weeks.
Second call, item 20.
Yes. Yes. You can finish in 15 minutes.
In that case, Lordship, if this matter can come up.
It's for promotion with effect from 1/4/17. With regard to counting of seniority, where the earlier court orders?
It's at it's Annex 1. So it will be page number 42. Annex 3, the last order. There is a specific direction for calculating my seniority from 2012, which has not been done as of now. Consequent to which my juniors have bypassed me, superseded me. And now there is another DPC. My junior, they got the promotion in the first instance as assistant sub-inspector. Now another DPC, they will become sub-inspector. And I'm still as head constable. It will take some time, Lordship, if it can come on Friday.
No, Friday is not a good day for you.
Monday.
Where is he now?
He's in Delhi now, as per my last instruction. On the first instance, I had qualified for the post of head constable, and I was given the movement order. I resigned from my post as constable.
Technical resignation?
Yes.
Yes.
Simply because that I was tested positive for HIV, I was reverted back to my.
Okay.
So that was challenged, because I was found fit otherwise. So that was set aside, and then there was a direction for giving my appointment as head constable. While doing so, they put a rider saying that his seniority will be counted from 2014, that is the date of his joining. Whereas I was selected in the year 2012. So against that, once again, I approached the Honorable Court.
So restored?
Yes, to be calculated from 2012. But that has not been done.
That's not considered till now?
Hence,
after 1 week, my lord. I couldn't go through the file.
Yes, on the prayer of the matter of the one. Yes, we'll see, because if it's a fact that court orders exist that ask for seniority to be counted from 2012, then deny.
Notionally, it is to, that is the order, my lord.
Excuse?
To count notionally, my lord, and monetarily from
2014.
2014, my lord.
That is
so even if for a purpose
as the
of
pay fixation
seniority,
will be done accordingly,
yes,
but actually it will be paid from 2014. I'll just go through the file, please.